repeat everything again. As I told you, greetings from Russia, greetings from Brazil. Thank you so much for the opportunity to talk to you today in our amazing webinar. My name is Elizaveta Gromova. I am Deputy for International Cooperation at South Ural State University, Russia, as well as Director for Cooperation with BRICS country at Brazilian Center for Mediation and Arbitration. And today, today we have our webinar within the amazing Rio de Janeiro Arbitration Week. And of course, thank you so much, dear Daniel Brantes Ferreira, for this opportunity to discuss our favorite topic. I guess all of us are fans here. Yes, and I will now introduce my esteemed colleagues briefly. So we have here Joshua Ellul. He is from Malta, from University of Malta, and he is director of the Center of Distributed Ledger Technology. And they both doing research and then to educate, and then they're educating students. And this is really, really amazing. And we also have Professor Evert Stamhuis. He's the chair of the Law and Innovation Department at Erasmus University, and they also have a Center for Digital Governance, so they also doing a research. Yeah, greetings, Professor. Nice to meet you. We also have Professor Reshef Kera, dear Denisa Reshef Kera. She's from the University of Malta, from the Center of Distributed Ledger Technologies. And also, yes, she will talk about Israel, right? A bit. Okay, from the car. And last but not least, of course, our dear Professor Chu Thi Hoa. She's Deputy Director of the Institute of Legal Science, and she's also working in the Ministry of Justice in Vietnam. So we have here truly international team of experts in regulatory sandboxes. So the topic sandboxes, for me, I will already tell all of you that I'm truly a fan, because I'm really glad that we have this opportunity to design the law, yes? Not from the up, right? Yes, like the legislator is deciding by himself and we should just adapt. No, we have the opportunity to create the law, to experiment, to test, and then create. And of course, for that, I love this truly unorthodox tool so much. Okay, and because our webinar today is called Global Experience in Regulatory Sandboxes, we decided to make it in a format of the interview. Yes, because we have, as you can see, dear participants, yes, our experts are amazing. Yes, they have amazing experience, but they all have research papers on regulatory sandboxes. And that is why, of course, we chose the format of the interview to discuss both national models of the regulatory sandboxes, yes, because national regulatory approaches in this area, of course, are very important. It is important for us to know, yes, and it will give us the opportunity to compare. So let's try this format. It is for me the first time when I'm doing the webinar in this format. Usually it is the PPT and the keynote. And for now, it will be interview. So, and I, of course, as a host, I will try my best not to fail. Okay, and our first question was about the sandbox, about regulatory sandboxes in the country you are representing. Yes, so I guess we will start with Joshua. because I already started with with you. So, does the country you are representing have regulatory sandboxes, and when was it launched? And can you talk briefly about the regulation?
Yep. So Malta launched a regulatory sandbox, a finance virtual asset regulatory sandbox and fintech sandbox. I believe that was around 2 to 3 years ago. But I won't go into depth on that particular sandbox because I think there'll be a lot of similarities to what others will talk about. And I'll talk more about the technology assurance sandbox that we introduced just under a year ago or so. So I used to be the chair of the Malta Digital Innovation Authority. It was a new regulator that was set up to make sure that these types of technologies are being used in a proper way when used in the context of blockchain, smart contracts, cryptocurrencies. And as we've noticed in this space, we're often creating legislation and we're creating regulation, we're getting it out there, and we don't even know yet if it's going to live up to the tests that it requires to, and the certainty that it requires to create in society. And also, if you look at MiCA and DORA and even the AI regulation, there's a lot of focus on making sure that technology is fit for purpose. And the one thing about audits, this is the first approach we tried in Malta is to introduce system audits. And they can be very onerous, they can be very expensive. And that means that we potentially will stifle innovation because startups, lower risk operations cannot launch their products into the market. And so we saw the need to lower these risks, lower these costs. And we did that by creating a technology assurance sandbox. And the idea is you do not have to fulfill all of the requirements that would be required for a particular technology assurance framework. But by doing so, in order rather to lower those risks, what we do is we impose some restrictions. So for example, you can't have more than 100 users in your first few months until the authority gains confidence that the application, that the service will work properly, and then you can scale up slowly. And so that's really the idea behind the technology assurance sandbox. And there's a number of applicants in the sandbox. I don't think there's any applicants that have been admitted yet, but I believe over the next few months, there will be a number of residents within the sandbox. And then we took it a step further. We were also collaborating with Open Loop, which is an initiative started by Meta, and really Meta are driving that. Focusing more on the AI regulatory and experimental policy design. So I have since left that post as chair of the regulator, and I'm focusing more on the research side. But I would say that's the unique position that Malta has provided.
So it is AI regulatory sandbox, right?
No, so it's a technology sandbox. So the laws, yeah, the laws that Malta had gotten out when it was regulating the blockchain space, besides the virtual financial asset regulation, focused on innovative technology regulation. And it started with assurances for blockchain, smart contracts, DLT, and all of that sector, but also artificial intelligence and safety critical systems were also included under the umbrella of that as well. And really, when you think about it, I'm actually a proponent as well that we should not have AI regulation. It doesn't matter if it's AI, if it's software, whatever it is, we need to make sure that these systems are fit for purpose, irrespective of whether the algorithm is artificially intelligent or not. So that's the approach that we took in Malta. And I think even Canada have taken a more of an automated digital process focus rather than a specific type of algorithm.
Okay. Thank you so much. And dear Evert, can you share with us the information about your regulatory sandbox?
Yeah. Let me just say that start with that the creation of acceptive legal regimes for experimentation and innovation date back until the global financial crisis of 2008, 2009, already wherein the Crisis and Recovery Act was a special provision for experimentation, but it was at that time not yet connected to an agile legislative process. It was more creating an acceptive regime so that at least in the in the ideas of promoting innovation and technical experimentation, regulations could be set aside for a limited period of time for a well-described experiment. And you can see that there are still, although it is an incidental regulation on the basis of the crisis situation at that time, it is still in place, and it is still used for now, let's say, purposes of, let's say, economic development and sustainability. And if you look at the list of projects that are accepted, then you can see that we see, let's say, so for example, sustainability, sustainable energy installation. So, and it's basically focused on, let's say, bypassing requirements and procedures with regard to construction, spatial planning, infrastructure, buildings and adaptations and so forth. And that, let's say, that were in the Netherlands the first steps on this road to, let's say, acceptive regimes for innovation and experimentation, and now sustainability. It was in the 2010s further extended to, let's say, create generic legislative allowances to trusted parties, particularly in areas where there is no regulatory authority, or and where there is, let's say, an organization, either a government organization or a hybrid organization, that was trusted with, let's say, experiment with new legal regimes. And there you could see that the agile legislative process were coming in. So there were, let's say, provisional legislation, and then a group of trusted authorities or organizations were allowed to, let's say, live under the experimental regulation for a while, and then give feedback whether this is going to be legislation for the near future or not. And we see that specifically in education legislation for quite a number of years already, and also quite recently it was introduced for justice administration. So, for example, civil courts could experiment under the specific experimental provisions to with new procedural devices. There was an explicit reference to technological devices or technological procedures, but it was not the aim in itself to develop technology. It was in the aim of, let's say, having a more agile legislative position from the central government, the legislature, the parliament, vis-a-vis the justice administrators in the country. And then, of course, in 2017, our financial regulators, we have in the Netherlands a Twin Peaks model with an authority, financial markets, and the central bank, who jointly supervise financial markets. And there you could see that they followed the famous British example, the FCA example, and in creating a fintech sandbox there. And of course, we will face when AI, the draft AI becomes actually law, then we will face this AI sandbox as well. And let's say the sharing experiences on the basis of these acceptance regimes is quite hard, because they are usually evaluated, if they are evaluated anyway, they are evaluated soon after their entry into force, and then usually, let's say, evaluation just upon entry. So whether it was accepted by the authorities or whether it worked, to a certain extent it worked, but what kind of empirical evidence it brought into whether it helped innovation or not, that is, let's say, out there yet. And I couldn't find any evaluation studies, for example, on the Crisis and Recovery Act, and still in place already for over 10 years, and even amended to, let's say, to lower the threshold to use it for more situations. And effectively, you could see here one of the risks of introducing acceptive regimes like sandboxes, etc., is that it is mentioned to be temporary and is justified to remedy a temporary situation, but then it becomes just a tool, a trick to lower procedural thresholds, and usually also to do some damage to reduce the protection of other interested parties. But I will come back to that, Elizaveta, if you ask our questions with regard to the upside and the downside of sandboxes. So I'll hold my peace now, and I'll mute myself and give the floor to someone else.
Oh, Evert, I definitely will, because I'm really so interested. So, as far as I understand, the legislation of European Union and Netherlands defined the spheres, right? The spheres where experimentation can be applied, right?
Yes.
And Joshua, in your country, it is not the spheres, but technologies, right?
Or so we have distinct sandboxes. So we have the fintech sandbox, and then we have the technology sandbox.
Okay. So in Russia, we have the federal law. It is called on experimental legal regimes, and it defined the spheres, not the technologies. Any technology, any digital technology, yes, we can test within these spheres like transportation, construction, financial market, and so on. Okay, and of course,
that's exactly one of the fundamental weaknesses of the endeavor of the European Union right now, because it is a temporary frozen situation about a certain technology, and then introducing, let's say, profound regulation for a specific technology which is still ill-defined. So I would certainly follow either the road of the sectoral approach, which was already there in the European Union for other things like consumer protection, or follow the road that the Maltese have given as an example, saying this is broadly for technology, but a specific technology with separate regulation. In 10 years, we will regret it, I'm quite sure. Maybe even earlier. But sorry, I interrupted you, Elizaveta.
No, that's okay. Because when I was comparing the legislation, all the BRICS countries, we wrote the paper on regulatory sandboxes in BRICS. So I checked India. India on the time had a bill on regulatory sandboxes, and basically they just listed the technologies. And that's all. And the list was closed. So just these technologies. So in half a year, we will have to make changes to this law because technologies are developing so fast. Yes. And different technologies appearing from day to day. I am now making some quick research on 5G. So I found that in European Union already have 6G. Please stop. I need to finish my paper. So yes, that is why, in my opinion, this approach is maybe not that good. Okay, and we have comments. Yes, Joshua.
Oh, it was just an answer to another question.
Okay, and I can't wait to listen about the experience of Vietnam. Professor Chu Thi Hua, are you with us? Can you hear me?
Yes. Yes. Now I can hear. Yeah. In Vietnam, totally we doesn't have any sandbox testing mechanism in the real sense yet. However, we have two projects similar to Sandbox. The first technology car sandbox, and the second mobile money testing. I can talk more about the technology car sandbox. In the period from 2014 to 2016, the initial time in Vietnam transport market Grab company from Malaysia reach out directly to taxi driver in my country by signing them up at the airport, at taxi queue or depot. The companies also educated taxi drivers on using the app by smartphone. And in November 2014, Grab Taxis launched its first Grab Bike service in the biggest city in Vietnam, is Ho Chi Minh City. And from 2015, Grab Bike motorbike service throughout Vietnam. And at that time, in January 2016, the Ministry of Transport of Vietnam passed decision number 24 which allows the implementation of technology application in the management and connection of activity of passenger transport under contract. And at that time, in Vietnam, there was Grab, Uber, only two company technology car. The duration of the testing is 2 years from 2016 to 2018. But in 2018, the Ministry of Transport extend the time, and until 2020. Until 2020, the project technology car testing and the Vietnamese government issued the decree to stimulate business and conditions for auto transport business. So the testing is end now.
Thank you so much. So the testing period is 2 years, right? So the experiment was for 2 years.
The first 2 years and extend 2 years more. So totally 4 years. Totally 4 years. Yeah.
Yes, because the right period for testing is a discussionable question nowadays, because in Russia we have AI regulatory sandbox, and this experiment, the length of this experiment is 5 years. So for 5 years, the companies had the right for some regulatory reliefs. Yeah, in my opinion, this is crazy. This is too much, because our consumers, other people, they are not protected. So that is why I always trying to check the period, the testing period from country to country. Yes, and in general, it is like 3 to 9 or to 12 months. Yes, in Australia, they have an enhanced regulatory sandbox, which is for 5 years, but this is mostly an exception.
I think 5 years. I think 5 years for sandbox testing is too long. I think 5 years is too long. Yeah. At first time, the technology car testing in Vietnam only 2 years, and we extended it totally 4 years. 4 years, and many people in Vietnam said it's too long for testing.
Agree. Thank you so much. And we have Denisa. Yes, can you share?
Yeah. Hi. Can you hear me? Okay.
Yes, perfect.
Yeah, I can finally talk. So I have a design and policy independent lab, we can describe it as such, in Israel for some time. I'm doing this research, and I'm still part of University of Malta, thanks to Joshua. And for me, I hope that things will continue because it's fascinating what they do in Malta. But I'm kind of moving my design and policy lab here in Israel at Bar-Ilan University from October. So I hope there will be more to show. But right now, I got into these issues of experimental governance, policy, sandboxes, basically from a very different, let's say, perspective. I was always interested in citizen science, in DIY culture, in these, I did research in hackerspaces, makerspaces. So for me, the interesting part was always the use of prototyping to set up policy. So this like experimental way of getting used to the technology, but also understanding how to regulate the technology inside these like communities. So that inspired my experiment with something I call exploratory sandbox. And in short, if I would have to describe my agenda, it is basically how to connect it with issues of public engagement. So what I don't like about present regulatory sandboxes in most places, they kind of involve like stakeholders from the industry, from the government. I don't know, like some serious stakeholders, but I don't see that many NGOs being part of the testing and experimenting. And I would like, of course, to see more like even public grassroots engagement that even doesn't have an organization. So maybe it's it sounds like naive or like crazy, but I wish these sandbox, I really believe it's essential in order to create legitimacy of these policy processes. And I'm in favor of experimental policy arrangements, because I don't like moratoria, and I'm not happy with this, after the fact type of regulations that are always too late and do too little. So I don't know, I think we don't have where else to go. We do need to explore these experimental ways of doing policy and governance of emerging technologies. And I'm very interested how more to involve the public and to involve these like elements of engagement I study and I'm very, very familiar with. And I completely share what Evert mentioned, like these frustrations that we don't have empirical data to figure out what is even going on with these regulatory sandboxes that are set up everywhere right now. I'm originally from Czech Republic, now I live in Israel. So, everywhere you hear, it's becoming almost like a fetish for any policy organization to claim they're setting up a sandbox. But in most cases, I don't see much happening beyond that. So I hope the purpose of this meeting would be also to maybe between us discuss like what type of empirical data we would like to see. For me, very interesting would be to see what type of stakeholders get invited, where, why, and so on. And then in terms of what Elizaveta just mentioned, how long are these sandboxes? Also in terms of who do they really involve? Are they really open to everyone, to the whole public? Do they cherry pick the people that will be the users or the subjects of what it's studied? And because my background is a bit philosophy, I have this general question of, okay, we have the special economic zones, we have these experimental sandboxes, we have some other formats probably of experimenting, but we also have a very beautiful metaphor of a trading zones from Peter Gallison. I'm a science technology studies scholar originally. And that's like quite an important metaphor that shows that yes, innovation actually happens when people can exchange in this like very direct way and together like create some form of future. So that's maybe in short what excites me, and I'm super happy to be here. I love what Elizaveta is doing, and I follow her for some time, and it's amazing that we also have this not just US universities environment. I'm happy that we have this really international, global community around these issues.
Dear Denisa, thank you so much. Thank you. Well, for what I love you, sincerely, for what I love you, for your non-standard approach. Yes, and when we invited you to deliver the lecture for our research group, we really enjoyed because we are lawyers. Yes, we have our way of thinking. Yes, and your way of thinking, incredible. It is different. And when we have this mix, yes, as a result, I think it can be something amazing. So thank you so much for the way you think. Okay. So dear colleagues, we have another questions, and maybe this question will be the most interesting, yes, because advantages and disadvantages of sandboxes, this is quite important nowadays. Especially we need to focus on disadvantages, yes. I like to criticize a lot. So let's have this opportunity, yes, to just at first to say some good words, yes, and then finally to criticize. Okay, Joshua, can you start?
Yeah, I'll start with the easy parts, with the good stuff. However, before I start saying that, I think we should use the right tool for the right job. I think sandboxes are good for certain things. Some advantages are we can react quickly rather than reacting too late. We can, in theory, we can put in evidence-based regulation based upon the sandbox. And so I think those are the advantages that I really see, especially when it comes to reacting quickly. Because if we look at, for example, the European MiCA laws, they've been in development for a number of years now, and we still have operators who have no idea what they're doing, what they're going to be doing. If we started with a sandbox ages ago, they would have been able to operate and slowly get there. So I definitely see the quick reaction as a huge benefit to the sector in general. But I'll just leave it at that, the easy part only for me.
Okay, let's start to criticize right now. Okay, Joshua, will you criticize, or it is better?
Oh no, I was just
someone
gonna
else?
to the advantages and then some others.
Okay, so let's discuss advantages, right? Right, okay. So Evert, can you tell us about advantages you saw?
Yeah, but I will drift into the disadvantages as well, if you allow.
Okay.
Since you love criticism as well. Let me say, well, first of all, I agree with let's say, the implied message of Joshua that it is, let's say, the responsiveness of the regulator is one of the benefits. So it creates at least something of an avenue in which regulators can be responsive, particularly those regulators that have traditionally, and that varies from country to country, a large distance to the market that they regulate. Another thing is that, let's say, the development process can be a bit more sophisticated because you add to it a real life experience. So let's say the prototype or the beta version, whatever. So in the development process, you can add a real life lab stage, and that I would say creates better risk policies for the release of the product finally to the market. But let's say my last advantage is also shaky because it is, let's say, it is a representation of innovation or innovativeness of an economy, of a certain jurisdiction, and there it becomes already shaky because there is very little empirical evidence of that. So does it really improve? There is already, let's say, let me just assume that innovation and the connection to innovation and economic development is there, or to prosperity or to well-being. Let's assume that there is empirical connection to that. But from innovation to sandboxes, it is, let's say, it is yet to be defined whether or not truly that is truly the case. And we have had these discussions quite recently about whether AI startups would be interested in sandboxing under the European Act, and then the companies that we were in this discussion, in this workshop, they just said, "Yeah, what does it bring me, right? So can I get a certificate or something like that, or a trademark, and then it may contain some economic advantage, but if not, if it's just a period of experimentation, well, I may be able to organize it myself, and I do not need to involve all the authorities with it. So it is unclear, and that is, let's say, also where we come to the downsides. There is a certain, let's say, I would say, ideological discourse on this is good because it reduces regulation, and little regulation is good for innovation. That is totally unproven. There is no evidence. There is evidence for the opposite as well. So it's, let's say, undecided and very heavily contendable. The risk issue is also there because of the prototype and the beta version that you release on the market contains some risk. And then I come into the, let's say, the justification for it. So is it justified to create risks, particularly not for the not involved persons, like the persons in the street, the unaware customers or whatever? That is it then justified, the risk, and what is then the accompanying risk policy of the experimenter? And we will deal with that if we talk about the possible conflicts that may arise out of it. But this is something really undefined in many regulations, and therefore one of the downsides. The next point I would like to mention is the regulatory capture that is almost automatically involved with this agile responsiveness of regulators and markets. So regulators close to markets, it is a good thing and a bad thing at the same time. And the good thing is that it is, let's say, it means that regulators do not define, let's say, merely theoretical conditions under which markets may operate, but on the other hand, it is indeed a food for capture, where the distance between the market and the regulator, particularly between the strong actors on the market, so incumbents or big companies on the one hand, and the markets on the other hand, if the distance is too small, as a result of which, let's say, certain interests are served by the regulation, by the responsive policies, and others are less served. And that is also my next move to the function creep. That is a serious risk in all acceptive regimes that carry the label experimental. Because function creep is easily going. I mentioned already that the Crisis and Recovery Act in the Netherlands is still in place and now used. And you talked about the periods. It's now used and say you can have acceptive periods of 10 years. It's not that an experiment takes 10 years, but the exception may last for 10, and now it is recently extended to 15 years. So acceptive regimes for 15, which effectively say you just diffuse the regulation in place for the project for eternally, because after 15 years, who is going to take down the wind turbine or the solar panel, whatever? It's going to be there. So that's why I would say this is an example of function creep that is always there if you talk about temporary and experimental thing. And let's summarize it in terms of, let's say, to what extent can you justify the benefits? Can you use the benefits as justification for the risks? And whether this has careful consideration in every case, defining the period, defining the participation, defining the access, that is, let's say, something to take good care of and not always very well tended to in all kinds of sandboxes.
Thank you so much. And I can see now this, yes, there's some connection, right, between, as Denisa told us, that we do not have enough empirical data, right? And Evert, you said the same. So basically how it was in Russia, for example, so we knew about this successful experience of United Kingdom, and they have a report like a regulatory sandbox lessons learned, and well, actually the data they are represented, they're really, really good. Yes. So we started firstly at the Central Bank of Russia, we started our first regulatory sandbox in 2018. We had some projects. Now they finished, but we can't find any information about this project. How was that? We don't know. Yes, because in 2020, we approved another law on regulatory sandbox. It is kind of general law. Yes, it is about regulatory sandbox. It's not for financial market, but as I told, for transportation, construction, and so on. So, but still, was the first experience successful?
Let me tell you an even stronger story. The financial sandbox that was created by our financial market regulator, all the participation and all the projects are considered to be under the statutory confidentiality obligation of the market regulator. As a result of which, we do not know anything about participating companies, projects, experiments, nothing. And if you ask for them, they can tell you that, for example, in a couple of years ago, it was rumor that there was very little participation, but you could not know. And that is, let's say, one of the very strong and very easy criticisms that you can have. It should be reported, not only for, let's say, protection of interested parties, NGOs that wanted to involve themselves in sectors, etc., but also for competitive industries. So because it is in effect a benefit that you allow for a limited number of competitors and not to all, because effectively, although you may have an open gate, in effect, you will not be able to accommodate all the participants, all in the market, not all the actors in the market. So in effect, a sandbox is then state support, which is not allowed on the European competition law anyway. But that's another issue.
Totally agree. Thank you so much for your comment. Professor Chu Hihua, are you with us? You disappeared.
Yes.
Okay.
Yes, I'm here. Yeah.
Okay. Can you tell us about some advantages and disadvantages of those experiments which were in Vietnam?
First, I think the advantages are the first, remove difficulties in legal regulation.
Oh,
yeah.
Of course.
The second, close supervision by state agencies. For example, for technology car, Grab car, Uber, or something like that. The Ministry of Transport and the Department of Transport very close supervise the operation and action of this testing. And the last, I think the last advantage is the pilot review measurement. After 4 year testing, the Vietnamese government issues the decree, the regulation. I mean the regulation replace the for testing. Yeah, and now we have a good decree. But the disadvantage are the number of pilot metronome is very little. Until now, in Vietnam, there are only two methods. The first, technology car, and the second, mobile money. The second is mobile money. Yeah, we have only two. I think it's very little. And the second disadvantage is the insurance mechanism is not clear. You know, in Vietnam there is a case, a suing loss from traditional taxi versus technology taxi, because in the sandbox, technology car sandbox, the agency sets the technology only the supply platform company, not transport company. You know, so the traditional taxis don't agree with it. I can tell a little about the case. So it is the limitation that have prevented the pilot becoming a sandbox in Vietnam now. And also we don't have any fintech sandbox at Spain. Yeah.
Thank you so much. So I guess the problem of regulation of regulatory sandboxes is it is the huge problem. So here in Russia, we have, well, our regulatory sandboxes are under a big critique. And one of the points, one of the disadvantages that we are discussing here is that maybe regulatory sandboxes, which are meant to be some flexible instrument, yes, it is over-regulated. So we have one federal law on regulatory sandboxes in general. We have another federal law for AI regulatory sandbox. If you want to create another regulatory sandbox for testing, for example, unmanned vehicles, which we already started, we need another regulation for this. So, and one of my colleagues, he once tried to consult me with this, like, can you please share the experience of other countries? Because here we are trying to prove that regulatory sandboxes shouldn't be over-regulated. And I said, yes, that basically this is just, you know, Russian feature, the feature of Russian model. Yes, we are trying to regulate everything. Yes, don't want to say about the quality, but we are trying. Yes, but when the colleague said, is that okay? So I said, I guess for Russian reality, it is okay, because this is the way we are doing it here. So we cannot do, like, you know, some guidelines, just, you know, approve some guidelines, or, you know, use this soft law. It won't work in my country. So that is why this over-regulation, on the one hand, yes, it is a problem. On the other hand, this is how it should be in Russia. at least for now. Okay, thank you, Denisa. Sorry, I love this tool, so I can't stop talking, but I I stopped and I want to listen to you.
I find fascinating your description of how different countries adopted the regulatory sandboxes from UK, because they were, I guess, the pioneers. And, you know, we often forget they have a very different law tradition. So maybe there is like some cultural and other reasons why they were the first ones. But in terms of what for me, like, so I don't represent currently any country. I mean, I would agree that in Czech Republic, at least what I've seen seems to me didn't really even start, and it will be this decorative use of sandboxes for something that was like a normal regulation. In Israel, and I'm not completely certain. I mean, what I did, I basically created my own city or a country in which we were testing how such a policy process can look like. And advantage I saw and I see still, I believe it democratizes in some way the technology, but also the policy process. So it doesn't close it just to experts. I do see that such more experimental prototype level of deciding how to adopt the technologies in some society offer, I don't know, some more like a hands-on experience, and it tests the comfort levels. It also like pushes for more transparency and so on. So I do still see some advantages of this process, at least in my imaginary community. I would create a community and I would do workshops where people would face a bias. And then as a group, we would have to decide what regulatory tools we have to use against this technology. In our case, it was blockchain and satellite data, just to explain what country I represent. And as a disadvantage, even when we were conducting the experiment, I see that it's, if you don't decide in advance who is doing the oversight, and I do see in most of these, there is like some missing division of power situation, yeah? In some way, like you hope this experimental sandbox way of doing policy will be some alternative to these like expert technocratic levels of doing policy, but at the same time, you end up in the paradox of them being even more like black boxes and actually even more like expert-driven decision making. So what I miss is exactly this: who is doing the oversight? Who do they have to report the data to? I mean, even in the case of the UK sandbox, how can we be certain that the data they reported are of good quality, and you know who, like, whose interests they represent? I mean, I wasn't so impressed by that report if you're talking about the same one. So yeah, missing oversight, like a bit of what happens in Las Vegas stays in Las Vegas. Like you have this feeling of you know, like a close community and not much transparency. And I think it's a pity, because I still want to see some policy processes that go the opposite way of this obsession with models and simulations, and you know, the algorithm tells me to do it, where you do have the level of engagement, you have to decide on issues of representation, who takes the risk, and so on. That's why I'm excited about them.
Thank you so much. And let's discuss our next question. Yes, so now we will pretend we are the regulators, or we are the legislators, and let's try to think how we would improve the national model of regulatory sandbox or regulatory sandboxes in general. So finally, we have this opportunity to be yes, to be the legislator or regulator. So let's start our fantasies. Okay, so Joshua, can you start?
Yeah, so I'll just also mention one disadvantage. Evert alluded to it, and I'll just expand on it slightly. Having a sandbox requires more oversight, which means more resources. And typically in certain sectors, it's very hard to find certain resources, especially in the emerging tech sector. So the burden that is the regulatory burden that is created on the regulator itself can be quite burdensome. So to get around this, even this particular disadvantage, I think, and also the disadvantages that were mentioned before, I think it would be ideal to have a principle-based general regulatory regime where you have to follow these principles to test out whatever you're testing out to come to whatever conclusion eventually. And that should be principle-based. Then you need an owner to handle this particular regulatory sandbox, and it could be a particular authority. And the authority responsible for that particular sandbox should have clear goals. What is it trying to do with respect to this particular test, this particular sandbox? In fact, we often think about sandboxes and legislation at two extremes. You're either in a sandbox or it's hard legislation, and we sort of have to change that. We could maybe start to think somewhere in between, where we have some legislation put in place that is very generic, very principle-based, wider, perhaps would say less restrictions, and slowly harden that legislation as we go, rather than have complete flexibility. So maybe that could be one approach, rather than having these two extremes, to think somewhere in between of incremental legislation. I mean, one potential possibility is when we're talking about certain sectors, like let's say crypto, blockchain, there's quite broadly, there are two classes of users. There's the techies who really understand what they're doing, and certain other individuals who really are at less risk using these platforms. And then you have the individuals who need more awareness, more education. So we could potentially also put in place certain restrictions to protect society and say, if you are an educated user, enter at your own risk. You know the risks. If you're not, you shouldn't be using this. And also perhaps putting certain onuses on the operators. But I think for me, the general direction would be to create this generic framework with gradual legislation that lowers the burden on the regulator, because you have these softer regulations just getting harder over time. Hope that makes sense.
Thank you so much. Evert?
Yeah, I think I can endorse very much what Joshua says. I would then be a bit more clear about the principles, and one of the and some of them he already mentioned. And I would issue this issue of transparency. I would want to be clearly as a principle, but also with regard to the relation in which those principles should operate. So transparency vis-a-vis the competitors, vis-a-vis the non-participating citizens in the experiment, and the participating citizens in the experiment, and of course between experimenter and regulator. So full transparency there. This is so this is how I would elaborate on this principle-based legislation. And another principle is, let's say, appropriate risk policy on all sides that can benefit from the experiment. So both the risk policy on the side of the regulator as well as on the side of the experimenter, because they earn the benefits, so they would have also some of the costs on experimentation there. I'm still, let's say, this in incremental. It's, let's say, another word for the responsiveness of regulation. And I'm still wondering, how could we do this without, let's say, being susceptible to intensive lobbying in the course of the incrementation, as a result of lobbying, of course, by those who already have a voice in the process, and not by the organizations that also would merit a voice. And this is also one of the things that you can see in the AI Act, where they say that we can recalibrate the risk categories: high risk, low risk, no risk, and forbidden technologies. The 4 categories, we can recalibrate those, and then they refer it to an expert procedure, which is meaning fully open to all kinds of lobbying outside the public eye. And there, so there I can connect to the transparency requirement again. And particularly for my country, I would say it is time to accept the experimentation from this confidentiality provision in the specific statute with regard to financial markets, because that is, in the end of the day, not a good idea at all. But that's, let's say, small, and it's I think it's not going to happen, but I can at least plead for it in this context.
Yeah, I agree, because we must see the result. Yes, that is why maybe somehow we should experiment with the confidentiality.
Let me just add, for example, Elizaveta, this transparency issue. If you go deeper into the innovation tabs on the website of the Authority of Financial Markets, you find something that relates to how they would want the experimentation taking place. That is, it's connected to their innovation policy. But whether they then abide by, let's say, scientific standards for appropriate experiments, for random selection, for control groups, and all those kinds of things, we don't know. Whether they require it from experimenting industries, we don't know.
Yeah. Thank you so much. Professor Chudhi Hoa.
Yes.
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 Can you share also your dreams? If you were a legislator, how would you improve the national model of Sandbox or sandboxes in general? I guess we have internet weak connection, right?
Yeah, you know, the State Bank is currently drafting a fintech trial merchants, only the banking sector. So in my opinion, I think the scope of testing only apply to the banking industries. Is very narrow. I want to open. I want to widen the scope to meet the private lending bond or fund certificates. Because in Vietnam, many they move out. Maybe to go to Singapore or Malaysia or American or another country to establish a business. They go to a foreign country to start up because at present we don't have any sandbox for fintech. So in my opinion, I want a fintech sandbox in Vietnam now.
Thank you so
much. Can you hear, Elizabeth? Yeah.
Yes, we finally finally we can hear you, but still maybe yes.
I'm sorry because in my city is now raining. It's raining.
Yeah.
Yeah. So the internet connection is not good. Yeah. I'm sorry. Sorry for any inconvenience.
No worries. We all know how it can be with technologies. We are all research digital technologies, yes, but sometimes we really do not know how to fix. So that is okay. Dear Denisa.
Yeah, it's fantastic that we can hear you from Vietnam and, you know, get a very different perspective. And it's definitely for me, like it was very interesting to hear, like which services you try to like look at and the issues that seem similar. Like it's fascinating to see we all face very similar issues in a way. So in terms of these like fiction of how it should be, I agree with the previous speakers, and I actually really like what Joshua proposed, that we should think of the users or citizens or these like end users more in terms of people maybe need to require a certain like certificate to use certain technology. So something about it, I like it, that maybe we should think of AI as some form of a gun that people need to proved that they are capable of handling and not hurting other people and themselves, of course. Something about it appeals to me, even if it puts the burden on the citizen, yeah, not on the society. But I would probably like to see some balance in it, something where we as a society are good in defining public good. And by public good, I really don't think we should stop just, oh, is it useful? Does it create innovation? Does it support markets and create like economic success? I do think as a society, we also have this curiosity about new things. So in a moment we stop researching whatever it is, GMO, AI, we are also losing, like we are damned if we do it and damned if we don't do it. So what I see we are trying to define is what is that balanced approach where we take some collective responsibility, we define public good, but we also allow people that are, let's say, more want to self-experiment or they have some other interest in these new technologies to have access to that. Something about it appeals to me. And I'll just mention with a PhD student of mine, we did a research of something called Soylent, which is this like they call it a baby food, powder food, like these people that don't want to eat, they created a substitute for food, Soylent. So we were researching these self-experimenting citizen science type of communities. And something that struck me among these people that sometimes really risk their health by eating these strange powders was that they often see themselves as astronauts or people like exploring the future. And I don't know, it sounded like ridiculous and naive, but it was completely honest. And, why should I be someone who says it's disgusting that you're eating these powders and think of yourself as astronaut? I actually appreciate that they are taking this risk and, sharing the results and so on. So I would like to see something balanced in that sense, public good, but also not patronizing the citizens and not making us children that someone has to take care of. And for me, really, the most important thing is that we define better what responsibility means, where I'm personally really not happy with the situations that we are like turning into these technocratic modes of governance where we use models and big data and we have this absolute trust in the technology as a better way of doing governance. I don't want to see that.
Dear Denisa, thank you so much. So, and if I were a legislator, of course, I would try my best. I do not know how, yes, but I would try my best to find this balanced regulation, to find the balance between the interest of regulators, of innovators, and the society. Well, in my opinion, regulator has its own interest, and when we are talking about the regulatory sandboxes, because regulators are the ones who are establishing, who are setting up this tool, so they have their benefits, right? And if we're talking about innovators, yes, we are now discussing that if innovators have some benefits or not. So in my opinion, they are applying regulatory reliefs or these experimental clauses, right? So in my opinion, they have. And another issue of this benefit is the competition. Yes, the threat to competition, because innovators who are participants, all the regulatory sandboxes, they have some benefits, while other participants, they do not have such. And this is actually the problem. Yes, so, and I'm now making some research on regulatory, I call it regulatory sandbox paradox. So is it the tool for developing innovation or it is a threat to the competition? So it is really interesting. But the society, the interests of society, the interests of consumers, they are not protected. Especially Evert already know because we have the paper on the topic. So the interests of society are not, if you're talking about the experience of Russia, for example, so the interests and the rights, they are not protected in a due way. So of course, I will try to find this balance this. We in Russia we say it golden middle, to ensure the rights of each. Okay. And if anyone wants to to pretend legislator more, we can discuss it. If anyone wants to comment, no? Okay. Okay, so we already share our desires. Nice. And we have last question. And I added this question because it is Rio de Janeiro Arbitration Week. And it is actually nice idea for, it is my and Daniel idea of the research paper, because we are making a lot of research together. He's the ADR professional, I'm more in technologies, and we are trying to combine somehow. And recently we started to think, what are the disputes which we can meet more often within the regulatory sandbox? Are there some types of disputes or not? And if there are some types, of course there are disputes. We cannot we cannot do without. So what if the alternative dispute resolution will be a good way to resolve? It is unusual question, yes, and unusual topic to think, yes, to discuss. But let's try, and maybe we will give a birth to some nice idea, and then we will write a paper together. Okay, so Joshua, can you start?
Yep. So I'll also touch on the last point that you mentioned. It's very hard to incentivize people to come into a sandbox. And in order to do so, then like Everett said, you might come up with schemes to incentivize them, but maybe that goes then against state aid and other problems there. So let's assume that we make certain sandboxes mandatory. So you can't operate outside the sandbox, you can operate in it. But then you have the situation where an operator might tell you, your sandbox has impinged on my success. So you have dispute with the regulator. Then we also have disputes potentially between the regulator, the operator, and the consumer, who are all pointing fingers at each other. So I think this is going to be a big problem when these large disputes do emerge, how to get around it. However, that's because there's a lot of flexibility given to the regulator. So I guess the less flexibility, the less subjectivity there is in a sandbox or in, let's say, a testing environment, the better the law will protect the regulator in that regard. So I'm not sure on the exact types of disputes that will emerge, but I can think that coming up with more rigid sandboxes might be a way forward. And I know that goes all against the ethos of a sandbox, but maybe having these well-defined principles could help limit different, at least, insinuations of liability.
Thank you so much for sharing your opinion, dear Evert.
Yeah, I would say that, let's say, alternative dispute resolution mechanisms, they have the air of being quick and agile, and therefore they would fit very well in the context of, let's say, the what we call incremental or responsive process of coming to, let's say, to a regulation that really fits the situation of a specific product or market or technology. I always, let's say, have a side thought on this. I always make the comparison of alternative dispute resolution in all aspects with the regular judiciary process. And if your judicial process is indeed slow, it takes 10 years or so to get a litigation to an end, of course, ADR is a good idea. But if you have an agile process with, let's say, trusted and independent judges in your country and a well supervised procedure, then what good would ADR bring other than, what would I know? The opportunity for power imbalances to exacerbate. So therefore, I have this sort of thought and second thought with regard to ADR, but let's take it as an agile alternative for slow courts. And then I would say it fits very well with the whole idea of this responsiveness or incremental rule production. policy production. And then I could imagine that the particularly the interested parties, so the operator and the regulator, would enter into an arbitration clause with regard to the conflicts that may arise between them with regard to, let's say, the effects of the regulation or the effects of the conditions under which to participate in the sandbox. Also, the disappointing results if the regulator does not allow the product after sandboxing to the market because of the outcome or the differences in interpretations of the outcome of the experimentation. There, I would say it's fairly, let's say, safe and justified to say, okay, this is part of your risk that you enter into an arbitration clause instead of going to the public judiciary. It's a bit harder for consumers because consumers are usually objects and not subjects in this process. So if you say we refer you to ADR, I would say that would really impinge upon their right of access to justice, because it starts with access to justice as to be provided by the state. Yeah, then you could say, okay, there is a voluntariness to it, etc. But that's another part of it. So let me summarize. Conflicts between regulator and operator are fairly fit for alternative dispute resolution, of whatever type it is. But we can imagine that it's easy to get a dispute over the interpretation of the test results, and for consumers it's a bit more complicated.
Okay. Thank you so much. So now I want to hear about Vietnam experience before I start, and Denise, of course, before I start sharing my point. Can you please switch on the microphone?
Yeah. So, you know, after Grab service has been approved for its service in Vietnam, it caused big controversy in my country between the traditional taxi company versus technology taxi, and the lawsuits between traditional taxi is a Vinasun company. Vinasun company brings the Grab company to the court, before the court. According Vinasun company, they said that Grab has not complied with the Sandbox because Grab is a taxi company, not only the technology company. You know, in the Sandbox in Vietnam, they said that Grab is at the first time they said that Grab is a technology company, not transportation company. So the traditional taxi company should sue the Grab because they want the government to set up the Grab or other technology company is a transport company, not only technology company. And the Vinasun said that the Grab has to pay 41 million Vietnamese compensate for Vinasun loss because of technology taxi. And the people court in Vietnam, the court in Vietnam have 3 trials. We have 3 trials, and at the end, the result that the council accept a part of Vinasun lawsuit claim. The judge decides the Grab company have to compensate the Vinasun company of 4 billion more than 4 billion Vietnamese đồng. Yeah, it's the result of the lawsuits.
Okay, thank you so much. Denisa?
That's a fascinating case, yeah? The graft in Vietnam. It reminds me of our situation with Uber in European Union and the scandal of them corrupting some of our top officials. But it opens this interesting issue of also the geopolitical context of some future possible, this whole geopolitical aspect of incubating a company that is not from your country and has this technical supremacy. So I don't know, maybe the arbitration is a good way to manage some of these geopolitical issues that may arise in the case of future conflicts. But I agree that maybe that will make it too much like I don't know how much it will help the citizens, honestly, in terms of like, how do we protect the future rights or possible interest, public interest. We are about to test it on a very funny format. We decided to run like a middle-age style trial of an algorithm in Prague in October. I hope it really happens. We want to basically find some evil algorithm and have this very public, in the Middle Ages, they would do trials of animals, basically, that were responsible for some harm. So we want to open this possibility of a public form of trials and engagement. And let's not forget, we have an example where the citizens actively protested against an algorithm, which was the UK case of these secondary school children that during COVID, they couldn't take the exam. So they were just, they just used a model to decide who goes where. So, I do see that we are maybe entering the stage where we will see citizens more engaged in trying to have this like a public form of justice. And I think we should support it because it creates a balance and it creates a strong reason maybe for companies in the future to want to be in the sandbox, so they prevent this public outcry or we prevent these potential geopolitical conflicts. But I'm just dreaming now.
Thank you so much for the dreams. Sometimes, yes, the dreams can be the reality. So that is why I love this sphere I'm doing. Yes, and we are all doing law and digital technologies. Yes, we still can dream, and maybe someday our dream will come true, because now this sphere allows everyone to contribute. Yes, and the regulators and governments and legislators, they're now listening to researchers, because this sphere is innovative. That is why we are all here. And I will talk a little bit about Russia. So I agree with all of you about the disputes. Yes, so of course this will be the disputes between regulators and innovators a lot. Yes, also this will be the disputes between innovators and consumers. The thing is that in Russia, alternative dispute resolution is not that spread like in other countries. It was very widespread. We had a system of arbitration. It was called Treteyskiy суды, Treteyskiy courts. But more than 5 years ago, our government canceled this system because there were, of course, many reasons, but one of the reasons was that the judges, yes, the arbitrators were not that professional. And now basically in Russia, we are trying to start to develop it. But we have arbitration centers mostly in Moscow, but not in the regions. So, for example, I'm from Chelyabinsk city, and we do not have arbitration center here. So basically all are in bigger cities, yes, but basically it is in Moscow. That is why, of course, for now, it would be good. Yes, it will be easier, maybe faster to use these ways like alternative dispute resolution. But for now, in Russia, it won't be convenient just because we do not have many arbitration institutions. So, okay, dear colleagues, I guess, yes, we are talking for about 2 hours here. Of course, I would listen to all of you for hour and hour and hour. So, but I guess we should stop. But maybe we have some questions to each others. So, do we have a question to each other? Yes, Evert.
I would like to hear the opinion of the colleagues with regard to the non-transparency of arbitration, because one of the, let's say, what I often hear, arbitration has a long history in my country already for many, many years. And of course, the eBay examples, etc., are there. I am curious about the issue of the transparency, because it is not, it's often sold as quick and secret. So again, closed procedure, closed outcome, everyone happy. But not everyone happy. The public has no access to it. So the learning effect that you may have from conflict resolution is very limited and not open to the public. And also, let's say, anything going wrong is not transparent as well. So I'd like to hear the opinion of the colleagues on that.
I mean, when it comes to a sandbox, I guess you do want more of that to be transparent. You want society to learn. You want every possible stakeholder to learn. I guess I can think of some situations where for those internal stakeholders, including the regulator, maybe it's better to keep some aspects non-transparent. So maybe there needs to be some subjective arbitrator who's deciding what can potentially be kept to them, but I think it just ends up being the same problem. Yeah, I'm unsure. I'm torn between.
Elizaveta, so can I say something?
Sure, sure.
Hello, I think that today our Vietnamese colleague, Dr. Hoa Chu, already illustrated some good best practice about the Sandbox initiative in Vietnam. Now, regarding the question, the issue raised from Elvis from the Netherlands, I don't know from what source of information that you heard about the non-transparency for dispute resolution in Vietnam. But let's say that I am an arbitrator from the Vietnam International Arbitration Center for over 20 years. So I joined my VIAC, my center since 2002. So up to now, I think that in Vietnam, if you don't trust the ADR, then you have to go to the cost for dispute settlement. And then Dr. Chu Hoa already mentioned about the dispute between a traditional taxi company and the technology company. And then that case have been heard by the court in Ho Chi Minh City. And in Vietnam, the court decisions are public. Nowadays, in the website of the court, the Supreme Court of Vietnam, it is a must. That means it is a requirement for all the judges to publish their decision online. So that means everyone can look at it and then can critique about the good side and the best side of those. So I think that nowadays, if you are the judges in Vietnam, you would have a big headache because you have to be faced with the transparency, right? So Vietnam belong to the civil country that in the past, the court decisions are public, but you cannot accept with that. But recently, most of our judgment have been published in the website. So I think that there's nothing to worry about the non-transparent issues. Now, let's talk about the ADR. Because ADR, let's say mediation and arbitration in Vietnam, because when the two parties they agree to choose the arbitration, then it must be kept confidentially, right? So, but everyone understood that ADR and including arbitration, it is the first priority is transparency, but it doesn't mean that everything public. That means it is kept confidentially. However, in our arbitration, the center, we must follow the rules of arbitration, and then the arbitrator should not be in unbiased or impartial. That means they need to be very fair in order to gain the trust of the disputing party. So I can see that during my 20 years of being an arbitrator for my center, there's not at all of my arbitral award have been overruled by the court. So I am very happy to say so.
Thank you so much. So surprisingly, the topic, the ADR, yes, topic became here for us very interesting and discussionable, yes. And I know that this is very popular topic across the world. So I guess we need another webinar on sandboxes and alternative dispute resolution. So let's just think about this idea. And so, dear colleagues, I want to say thank you. Thank you, of course, not just for being here today, but of course, that was truly amazing. And I learned so much from all of you. Thank you so much, but mostly for the research you are doing. This is really, really important that you are all developing this research direction, law, digital technologies, regulatory sandboxes, because we are researching the future. So thank you so much. Спасибо большое. It is in Russian. I hope we will cooperate in the future. Let's arrange something. Also, so thanks. Thank you so much and see you.
Thanks, everyone.
Thank you.
Thank you.
And see you all.
Thank you, dear colleagues. See you. Bye bye.
So in Vietnamese we say tạm biệt.
Yeah.
Bye bye.
До свидания.
Tot ziens.
Bye bye and good night, everyone.
Thank you so much.
Thank you.
No photo today, right?